Okay, good afternoon, everyone. Welcome to this webinar hosted by Wee Swee Teow LLP. Thank you for taking time during this lunch hour to join this webinar. It is scheduled for 1 hour. We have two speakers, Ms. Choon, who is our partner in charge of Family Law Practice Group, and Mr. Lee Chang, one of our associates from our Real Estate and Private Clients Practice Group. We have allocated about 20 minutes for a Q&A session. At the end of their presentations, I will invite them to field the questions. Only the presenters and myself and my team will be able to view the questions, so feel free to key in your questions at any time during the presentations. You will find a button at the bottom of this webinar screen, and just click on it and type in your questions. Today's seminar subject matter came about when one of our team members wrote an update on the recent court of appeal case of USB and USA. The speakers will share more about the case in their presentations. We have pondered over whether to hold today's seminar. After all, marriage disputes are not, or marriage dispute is not a happy topic. Marriages are intended to and should last forever. But the reality is that this topic is in the minds of many wealth planners and their clients. How can I preserve my gifts to my children if their marriages break down? Is always a common question, as I'm sure many of you will attest to. So at our firm, we decided that to avoid such question is like the proverbial ostrich which buries his head in the sand. So as responsible advisors and counselors to clients, we must let this question surface and deal with it if there is such an issue. And it is our hope that when such issues are openly addressed, in the process, marriages can even become stronger. And with this context, let me now introduce our first presenter, Ms. Choon. Choon has been in practice since 1999. She doesn't like me to say this, but this is the last century. She has advised on many matrimonial disputes, and she's passionate about helping clients. In her own words, she gets a lot of satisfaction from helping them not only on the law, but also from counseling them. And I think that is a great and admirable task to a perspective to start from in this difficult area of practice. Chang has been in practice in our real estate and private clients group since 2008. Although he is relatively young in practice, his maturity and sensitivity to areas beyond the hard law makes him a very effective advisor in this area of practice. So let me now hand this session over to Choon. Choon, over to you.
Thank you, Soo Chye, for the introduction. Hello, everyone. I'm Choon from Wee Swee Teow LLP. Today's webinar, we're going to talk about wealth preservation, and we will be speaking in the context of two scenarios, which actually came about from two recent reported cases in our local courts. The first scenario that we will deal with is a husband and wife, whereby the wife purchased 10 properties before marriage, and she then purchased 7 properties during the marriage. Now, the properties that were purchased before marriage were not fully paid up by the time of the marriage. So the wife was still continuing to service the loans for these properties during the marriage. And we're going to look more closely at what will happen to these properties when the marriage unravels. We now move over to the second scenario that we're going to talk about, which is a husband and wife, whereby the family runs a family business. The husband worked with the father, and the wife also joined in a family business after marriage. Okay, so before marriage, what happened was the husband gave the son 20,000 shares in a family business. And along the way, husband and wife were both working in the company, and the wife then decided to stop working in a business when their third child was born. And at around the same time, the husband gifted another 60,000 shares to the husband. So we will also look at this case to see what will happen to these shares when their marriage unravels. When we go into what happens when a marriage unravels, we look at the process in two stages. The very first stage is actually to deal with the dissolution of marriage, and that will depend on what grounds the parties will dissolve the marriage. And when that is dealt with by the courts then look at the second stage of the dissolution, which is the ancillary matters. And these ancillary matters will cover the issues of the children, which will be the child custody, which parent will have care and control, and then the other parent will have access to the children. The second issue of ancillary matters would be the division of matrimonial assets, and finally the maintenance for the child and the spouse. We will want to tie this all up to how we look at succession planning, because families will be very concerned that when one of their family members' marriages unravel, how would that impact on the family's assets? And key assets that could be affected will be real estate properties, family businesses, etc. And we look at how division of matrimonial assets would or could affect succession planning. And we will also explain that even in assets which are legally under one spouse's name can still fall into the matrimonial pool and be exposed to division when the marriage unravels. So the key points that we want to look at is the impact on asset protection as well as on wealth preservation. Now, how does the courts deal with the division of matrimonial assets? The division of matrimonial assets is actually set out in the section 112.10 of the Women's Charter. And what will happen is that the courts will first need to identify what are matrimonial assets. And the definition is actually set out in the Act itself, but we have presented it into a table for you to understand it more easily. And when we talk about matrimonial assets, what the court does, it looks at what assets were acquired before the marriage by one spouse or both of them. And it will see that on the basis of the facts of the case, for these assets that were acquired before marriage, what happens to them during the marriage? Was it ordinarily used for family life? Was it substantially improved during the marriage by one spouse or both spouses? Now, if it was ordinarily used by the family or if it was substantially improved during the marriage, even though it is acquired before marriage, these assets will become matrimonial assets, which will be open for division when the marriage unravels. Secondly, if it's assets acquired during the marriage by one spouse or both spouses, such assets will also be considered matrimonial assets. And we also have the matrimonial home. As long as the home is owned by either of the parties and is used as a matrimonial home, it will become a matrimonial asset liable for division. We then look at what are the non-matrimonial assets. Assets acquired at any time, with the exception of the matrimonial home, by one spouse from a gift or inheritance, and which has not been substantially improved during the marriage by one spouse or both spouses, will not be a matrimonial asset. So broadly, these are the definition that we derive from the Women's Charter on what is considered a matrimonial asset. We then move on to look at how would these assets be divided. And again, we look at the sections from the Women's Charter, and it states that the court shall have power to order the division of any matrimonial asset or the sale of any such asset, and the divisions of the proceeds will be in such proportion as the court thinks just and equitable. So this might seem like quite a vague power, but what we do is we seek guidance from decided cases on how the court has applied this power in the division of assets to cases. And we will then look at the statute again, where it does set out the circumstances which the court must have regard to when considering division of assets. We just set out here a short list, but actually there's quite a long list of factors and circumstances which the court will look at. But briefly, we set out here, the court will consider what the contributions made by each spouse towards acquiring, improving, or maintaining the matrimonial assets. It will also look at the debt owing or obligation incurred by either spouse for the benefit of the children of the marriage. Of course, very importantly, we also have to consider what are the needs of the children of the marriage. And it will look at the contributions made by each spouse towards the family's welfare, including looking after the home or caring for the family. Okay, and the list does go on, but these are the ones that we'll touch on briefly here. So how has the court applied these circumstances and the power in their cases? We have to take guidance from the Court of Appeal decision of ANJ and ANK, which has set up clearly the structured approach which the courts must adopt when they look at division of assets. So what happens is that the court will look at, for every asset that has been acquired, the court will look at the ratio which represents each party's direct financial contribution to those assets. And secondly, they will ascribe a ratio that represents each party's indirect financial and non-financial contributions to the assets. Using the above ratios, then the court will derive each party's average percentage contribution as the basis to divide the entire pool of matrimonial assets. I will now hand over to my colleague Chang, who will then apply these principles to the scenarios which I have just set out earlier. Chang?
Okay, thank you, Ms. Wee. Okay, so we're back to the first scenario. Just to recap the salient facts, the wife purchased 10 properties before marriage. These properties were not fully paid for by the time of marriage, so the wife alone continued to service the mortgage loan during the marriage. During the marriage itself, the wife also purchased 7 more properties. So one of the issues that the court had to determine was whether the properties purchased by the wife before marriage and paid for by the wife alone during marriage are considered matrimonial assets. Okay, another salient fact is cohabitation. In this case, the couple had cohabited for 12 years before marriage. They were then married for 5 years before the marriage breakdown. So another issue that the court had to decide was the impact of cohabitation on the division of matrimonial assets. In particular, should the parties' indirect contributions during cohabitation, which is before the marriage, be taken into account in determining the extent of their respective contributions to the marriage. So this is in the recent Court of Appeal case of USB and USA. Okay, in the case of USB and USA, the court helpfully set out the boundaries of matrimonial assets. Okay, so basically, matrimonial assets are assets that are subject to the court's powers of division at the end of a marriage. So the court started by identifying 4 classes of assets that the parties may possess. So on the screen, you can see in the top left corner, you have the first class of assets known as the quintessential matrimonial assets. These are assets that are acquired during marriage, and they are clearly matrimonial assets, regardless of whether these assets are acquired by applying one spouse's own money or by income earned during the marriage. Quintessential matrimonial assets also includes the matrimonial home, whenever and however acquired. So for these quintessential matrimonial assets, the entire value would go inside the matrimonial pool to be divided upon the breakdown of a marriage. The second class of assets, top right corner, you can see is the pre-marriage assets. So basically assets acquired before marriage. Generally, these assets will stay outside of the matrimonial pool unless they are transformed. So we'll look into this concept of transformation shortly. Okay, the next class you can have is gifts and inherited assets. So regardless of when these assets are acquired by one spouse, by gift or by inheritance, they do not form part of the matrimonial pool unless they are transformed. So the last category at the bottom left corner is transformed matrimonial assets. These are assets that are acquired before marriage or gifts and inherited assets, but they are subsequently transformed. So once transformed, the whole asset will go into the matrimonial pool. So now we know that non-matrimonial assets can be transformed into matrimonial assets. The transformation can occur by two means. One is substantial improvement of the asset. Second, it's by ordinary family use or enjoyment. Okay, we look at substantial improvement first. So the Court of Appeal helpfully clarified the meaning of substantial improvement. Basically, it entails the investment of monies or money's worth, and there must be some expenditure or effort by the non-owning spouse or both spouses towards the measurable economic improvement of the asset. So the indicator is economic improvement of the asset. We'll look at some examples. Okay, example one is renovation works to the property. This is what the court calls a paradigm example. Okay, in order to count for substantial improvement, there must be an increase in the property's sale or rental value. Or alternatively, through the efforts of the other spouse, the non-owning spouse, a barely habitable home is made much more comfortable. So the underlying theme here is that there must be the investment of money or money's worth towards the substantial improvement of the asset. Okay, we'll look at a second example, spouse's business. Okay, so if the asset is a business that belongs to one spouse, the development of the business by the other spouse during marriage through sustained efforts can transform the asset into a matrimonial asset. Okay. Again, the court commented that there should be an increase in the turnover or profitability of the business. So that is a reference to the economic improvement of the asset. The court also commented that carrying out administrative or minor public relations activities or being a nominal director may not suffice. Okay, ultimately, whether a spouse has made substantial improvement to an asset would boil down to the facts of the case. Okay, but even if an asset has not been transformed, the efforts of a spouse can still be considered as part of his indirect financial contributions and be taken into account in a division exercise. So if you recall what Ms. Wee was sharing earlier, stage one is you identify the matrimonial asset, stage two is the division. So even if the spouse's business is not part of the matrimonial pool to be divided, it can be taken into account. The efforts can be taken into account when it comes to the division of the pool. But the only issue is that now the pool is smaller because the spouse's business does not come within the matrimonial pool. Okay, another way of transforming assets is by family usage. So the use of the asset must be usual and relatively prolonged rather than casual. So one example that the court gave is a matrimonial home. So if you have a property that's acquired and fully owned by one spouse before marriage, and you have another spouse, the other spouse moving in after marriage, then the property is used as a matrimonial home, it will be considered as a matrimonial asset. So this is a clear-cut example. Another example that the court provided is a pre-owned family car. So for example, if you have one spouse who owns an MPV car, and the car is used regularly during the marriage, to ferry family members around for school, for shopping, for family outings, then the MPV car may be transformed into a matrimonial asset. In contrast, if you have a pre-owned sports car, which is owned by one spouse and only driven by that one spouse, and the children are taken out for a spin once in a while, then perhaps in this scenario, it may not be regarded as having been transformed. So the use must be usual and relatively prolonged. Okay, so these are the four classes of assets that the court have identified. And we move on to one of the issues of mortgage repayments. So in the case of USB and USA, the wife had purchased the property before the marriage and continues to service the mortgage loan by her own efforts. So in this scenario, the court considered that the portion of the property representing the repayment during marriage would fall within the matrimonial pool. So for example, if 20% of the mortgage loan was repaid during marriage, 20% of the property would fall within the matrimonial pool to be divided, even though the husband has not contributed towards the mortgage repayment. The second scenario here is where the husband has made substantial payments during the mortgage loan. If substantial payments have been made towards the mortgage loan, then by substantial improvement of the asset, the entire property will become a matrimonial asset. So some of you might think, that it sounds a bit unfair. If the wife has been the one that is servicing the mortgage loan during the marriage, the husband did not contribute. Why should the husband get something, out of the property? So the court's reasoning is as follows: that if you earn income during the marriage, this income would have been quintessential matrimonial assets. And now the income, instead of saving it, it's used to pay off the mortgage loan. So therefore, the portion of the value of the asset that was acquired during marriage should go into the matrimonial pool. Okay, the next slide. Okay, so basically here it's a table showing on the left column the matrimonial assets, on the right column the non-matrimonial assets. We have beefed up the table a bit more based on the clarifications of the Court of Appeal. So you can see at the third row, assets acquired before marriage to the extent paid for during marriage will be considered matrimonial assets. On the other hand, assets acquired before marriage to the extent paid for before marriage, these would still be non-matrimonial assets. Okay, the next issue that the court dealt with is cohabitation. So the court identified the prevailing ideology of marriage based on the Women's Charter. Okay, it is an equal cooperative partnership of efforts. Okay. So based on this fact, the court studied the Women's Charter, and based on the Charter, they identified that the provision in question deals with powers of the court to order division of matrimonial assets. So the underlying statutory policy is that if there's any contributions to be made and to be taken into account in the division, it is those that are made during marriage and not during the cohabitation process. So assets acquired during cohabitation do not fall within the matrimonial pool. So similarly, if parties have made indirect contributions during cohabitations, this should not be taken into account in determining the extent of their contributions towards marriage. Okay, the second scenario that Ms. Wee was describing earlier, basically you have a husband that's working in the family business. The wife joined after marriage and worked substantively for the business until the birth of their third child. So before marriage, the husband's father had given the husband 20,000 shares. At the same time that the wife stopped working for the business, the husband's father gave the husband another 60,000 shares. So this is the recent Court of Appeal case of UEQ and UEP. So we'll look at how the court dealt with the 20,000 shares and the 60,000 shares. Okay, first for the 20,000 shares, okay, the court upheld the High Court's finding that the wife contributions had substantially improved an asset belonging to the husband, which was acquired by way of a gift. So the 20,000 shares was given to the husband before marriage. The wife then contributed substantially to the business, so it improved the asset. Okay, and by this substantial improvement, the 20,000 shares is now considered a matrimonial asset. The court found that the wife had played a fairly important role in the day-to-day administrative running of the business. So when at the time of the gift, the company was just incorporated, the par value of the share was $1. By the time the wife stopped working for the business, the court found that the net tangible asset value of the share went up to $3.63. So there is an economic improvement of the business of the asset, which is the shares. and at a material time of the wife contributions, these 20,000 shares were already owned by the husband. So the wife contributions in this case had substantially improved an asset belonging to the husband which was acquired by gift. Okay, then we look at the 60,000 shares. For the 60,000 shares, if you recall, it was given to the husband at the same time that the wife stopped working for the business. So in this case, the court said no, the 60,000 shares are not a matrimonial asset. And the reason is that the improvement of the gift must come after the gift is acquired. So the wife has stopped working for the business at about the same time that the 60,000 shares were gifted to the husband. So the starting point is this: there's a presumption that if I give a gift to someone, I do not intend his or her spouse to have a share in it. But there is an exception, if the gift has been substantially improved by the other spouse. So this is the exception that is provided in the Women's Charter. If there's a substantial improvement by the other spouse, it will be considered a matrimonial asset. In this case, we can argue that it is just and fair for the other spouse to have a share in this asset. So conversely, after a gift is made to the spouse and there is no substantial improvement thereafter, subsequent to the gift, then the gift is considered a non-matrimonial asset. Okay, so now I'll pass over to Ms. Wee. We'll be sharing on some of the approaches that families can consider in asset protection.
Yes, now that we know how the law deals with division of matrimonial assets, and more importantly, what is considered a matrimonial asset, we wish to discuss about the approaches that we can take to protect the assets. And the first approach that we're going to talk about is keeping these assets untransformed. You have seen from the examples that for assets which are acquired before marriage and transformed during the marriage will be considered a matrimonial asset liable to be divided. So we have to consider how we're going to ensure that the assets acquired before marriage, firstly, we want it to be fully paid up, right? Because in the case of the scenario 1, where the wife was still servicing the loan during the marriage, the asset became a matrimonial asset. But if she had completely paid for all the properties before she got married, then these assets will be kept separate and would not be considered matrimonial assets. So secondly, we want to think about how we're going to ring fence the assets which were brought into or inherited during a marriage, right? So sometimes the spouse might have received an asset as a gift or inheritance from his parents. He has to think about how he wants to ring fence his assets so that these assets do not be considered matrimonial asset during a marriage. And he can do this by thinking of how he can keep his assets separate and avoid commingling of the assets. Secondly, when we talk about another approach, would be parties entering into agreements. So there are two types of agreements. You can have an agreement which is entered before the marriage, which is the prenuptial, or you can have an agreement that's entered during the marriage, which is the postnuptial. And for these agreements, parties decide what's going to happen to their assets when the marriage unravels. Now, we just have to emphasize that while such agreements can be made, they cannot be enforced in themselves. The discretion of the court will ultimately decide how much weight will be given to these agreements, if at all. And the ultimate division is still ultimately the decision of the courts based on all the circumstances that we have set out earlier. The court will only consider these agreements as one of the factors of the whole list of factors which they have to consider when they divide. For the last approach, I will hand over to Chang to go through.
Okay, the last approach that we are considering here is that of a trust. So basically, you have a settlor who sets up a trust and contributes initial assets into the trust. So this is done by executing a trust deed. Okay, once you execute the trust deed, the trustee that is appointed will hold the legal ownership of the assets for the benefit of the beneficiary. So once an asset is set up upon trust, the ownership of the asset is taken away from the settlor and no longer forms part of the settlor's assets. So if they don't form part of the settlor's assets, they will not form part of the assets to be divided upon dissolution of the settlor's marriage. So this is one way of protecting the asset from breakdown of marriages. But we continue to look at the next level, which is the beneficiaries level. Okay, even if the asset no longer forms part of the settlor's assets, it may still form part of the beneficiary's assets. Okay. The gift may then form part of the beneficiary's matrimonial pool if the gift is transformed. So when the beneficiary's marriage breaks down, it is still subject to division by the courts. So we can consider another strategy, which is a discretionary trust. Okay, so in the previous slide, we saw a fixed trust where the beneficiaries and their respective share in the property, in the asset, is fixed from the outset. In contrast, what you have here on the slide is a discretionary trust, whereby the beneficiaries and their respective shares are not fixed. Instead, the trustee is given the discretion to select the beneficiaries and to determine the amount to be distributed to each beneficiary. So usually, the trustees will be given a letter of wishes by the settlor. So this letter of wishes that's done up by the settlor is not legally binding, but it can guide the trustees on how the settlor wishes for the assets to be distributed. Okay, so it can guide the trustees to ensure that the settlor's personal wishes are carried out. Under such an arrangement, the beneficiaries, they can only benefit from the family assets without inheriting or owning them. Because unless they are selected as a beneficiary, then they are essentially only a potential beneficiary without having an actual right, a beneficial interest in a property. So in this case, you can have the capital asset, it is not vested in a beneficiary, but the beneficiary can enjoy, for example, the right to stay or rental payouts, or if it's a company shares, dividend payouts. But these are distributed to the beneficiaries upon the discretion of the trustee in accordance with the letter of wishes. So the asset itself is protected in a sense that they do not form or they do not fall within the beneficiary's matrimonial pool. The trustee is then given this flexibility to deal with the change in circumstances of the family. So it also protects the family assets from divorce, creditors, or a spendthrift lifestyle. So the discretionary trust is quite a powerful device in estate planning. Okay, that's the end of our presentation. I think we will move into the Q&A segment.
Okay, thank you, Chang Yang. Thank you, Choon Wai. Okay, let me now move this. Okay, we have a few questions. Let continue, please, to just put them, send them in. One question, I suppose this one, okay, I don't know, Chang Yang or Choon Wai can, either of you can answer it. My family home property is owned solely by my spouse. I merely contribute to all the monthly maintenance conservancy charges, SP bills, children's education costs, and all family expenses. Can the property be willed away 100%? Okay, this property is held by the spouse. Question, can the property be willed away 100%? Or in the event that should happen, presumably when it's willed 100%, can I contest for 2/3 of the share? Choon Wai, Chang Yang, any one of you want to take it?
Maybe I'll take this on. Basically, we're looking at what happens if a spouse solely owns a property and then wills it away. Now, if he wills it away but he hasn't died, then and the parties' marriage unravel, then all the principles that we talk about will still apply. If it's if it was used as the matrimonial home, then it will become a matrimonial asset for division. If it was not used as a matrimonial home but substantially improved on by the other spouse, again, it will become a matrimonial asset. If the marriage did not unravel and then the spouse who owns the property dies, then matrimonial law doesn't come into play anymore. Estate law will come into play. And how that property will be distributed will then go in accordance with the will. So in that event, if that should happen and the spouse willed it away to somebody else without including the living spouse as a beneficiary, unfortunately, the living spouse will not get anything. And that would be the position.
Thanks, Choon Wai. Is there any recourse for a family member who actually requires the provision and support and maintenance of the spouse that has passed away and has not left anything to these dependents?
Yes. So for a spouse who's passed away but did not leave anything to their dependents under the will, the dependents will have recourse under another statute to claim for maintenance to sustain their livelihood. So they could take out the application under that statute.
Yeah, thanks, Choon Wai.
Yep.
Okay, another question. Slide 32. Is there a rule upon which an asset must be settled for a certain period before it can be considered to be out of the matrimonial assets? I suppose we're talking about whether there's any period before that property no longer is in the considered in the hands of the estate. Anyone?
Maybe I'll just attempt this question. There is a specific provision in the statute. I can't recall offhand, but basically the idea is the idea of a trust. If you're setting up a trust for the benefit of, say, your child, a beneficiary, it is essentially a gift. Okay, the trust is essentially a gift. You're gifting the property to your child. The trustee is holding the legal ownership, but the beneficial interest is still with the child. So in the case of a gift, can it subsequently be challenged by the other spouse to say that, you know, it has been dissipated before the breakdown of marriage? If I recall correctly, right, the safe period is 3 years provided in the statute books, but I can't recall the provision offhand. It's a bit similar to, you know, if you know that you are going to face a bankruptcy proceedings and you quickly set up trust, you know, give away your assets to your family members, there is a 3-year period where it is subject to being challenged, to being recalled by the courts when the creditors apply to set aside those gifts. So the idea is the same. On this question, there's a related point that I wanted to share earlier. The trust itself, right, it is not a foolproof way to exclude the asset from the matrimonial pool. It all depends on the facts of the case. So for example, if you have a settlor who purportedly sets up a trust of a property, gift it to a third party, but the settlor reserves a lot of powers under the trust deed for himself. You know, in this situation or in that situation, you know, I get to take the property back for myself. Then in this case, IRAS might come after the settlor to say that, hey, have you actually really given away your property? Or, you know, you're just trying to evade your liabilities elsewhere. So if the settlor holds too much control over the asset, then the trust device might still be undermined and might not work in favor of the settlor in the event of the breakdown of the settlor's marriage. So these are some of the considerations that have to be taken into account.
Yeah, thanks, Chang Yang. Choon Wai, from a practice point of view, Any thoughts you want to share on this particular point? I mean, surely do the courts have the discretion to actually look at the conduct of somebody who tries and evade their responsibilities?
Definitely, the courts would go behind such actions to see what are the motives for doing it. And if the other spouse can satisfy the court that these acts were done just to avoid assets being put into the pool for matrimonial division, the court has the power in when it does its division to attribute a certain percentage back to the other spouse if they find that such conduct did actually occur.
Yeah, thanks, Choi. Another question: Can the matrimonial asset be settled into a trust by one spouse who has full ownership of this asset? Can the other spouse challenge or prevent it? Choon Wai?
Yep. Well, it's a bit tricky because while the spouse having ownership of the asset can technically do whatever he wants with it when the marriage is still on. If the parties are already going through the proceedings, then I think the other spouse would have avenues to go to court to take out applications to stop that from happening. But if things are still going well and one spouse chooses to place his assets under a trust, I think the other spouse would have difficulties preventing that from happening.
Yeah, I suppose the reality is that if the marriage is in trouble and one spouse tries to do such things with a view to avoiding the consequences of that asset being part of a matrimonial pool, I suppose at this moment, based on the law, the court does have discretion to distribute eventually the assets on a full, on a just and equitable basis, right?
That's correct. Yes.
Yeah. Except that if this is the main asset, then it may be either an in or out kind of situation. If it's a matrimonial asset, it's subject to division. If it's not a matrimonial asset, it's not subject to situation. Are there many such cases in your decades of practice?
So far, I've not encountered cases where parties deliberately put their assets on the trust to avoid division. Yeah. But
And I suppose, that probably is not the right thing to do, huh?
yeah.
Okay, thanks, Joy. There's another question. How will a trust arrangement impact a family business? Would a bank extend loans to a company where shares are held on a trust? Any one of you? Okay. Okay, I do a fair bit of this area of practice. How will a trust how will a trust arrangement impact a family business? Typically, it shouldn't. Vis-a-vis third parties dealing with a family business, it's just they are dealing with the company. If you're looking at how if you're looking at that question from a context of how you affect the arrangements between the family members in the business, yes, then it will set up how the family must come together and agree on how they want to do this. For some families where the businesses are substantial and the patriarch or matriarch is trying to plan what to do next for the next generation, we have come across families which are considering or have considered family constitutions, where the whole family will come together, led by the matriarch or the patriarch, to come to discussions on what a consensus is amongst the family members in running the business should the matriarch or the patriarch one day not be around. Right? So in those circumstances, sometimes it could be a trust arrangement. You've got situations where actually trust or all the shares of the patriarch and the matriarch can be settled into a family trust. And then the matriarch or the patriarch will still in his lifetime be running the whole, giving directions and making decisions. But on his passing, like what Chang said just now, a letter of wishes, there will be certain intention that will be stated in a letter of wishes to what to do. But this kind of arrangement can be quite complex, number one. Number two, sometimes I have to tell clients, is it really practicable for you? Beyond just a trust arrangement, there are other structures that must be put in place to ensure that maybe the trust arrangement just deals with ownership, but in terms of management, it's a separate way of dealing with, there will be a separate way of dealing with things. So it can be quite complicated. In most of mere mortals like myself, I don't have to think very much for my own business and all, but there are, we will know of many families or some families with huge businesses, conglomerates, you know, businesses that have been around for hundreds, for many decades, some even maybe a century or two in some of the European countries, where this kind of arrangements may not be uncommon. Would a bank extend loans to a company shares of which are held on trust? Really, if the loans are secured by the company, it is, I suspect, just a commercial decision on the bank. But just because the shares are held on trust, I don't think by itself would be a limiting factor to the facilities that the business or the company may get from the banks. Okay. Okay, another question. I think this one, Choon or Chang, how does the court assess what is substantial economic improvement? Is there a percentage?
There isn't any percentage prescribed by the cases. Every case would have to be looked on the facts of itself, and the court will then exercise its discretion of whether certain conduct or acts alleged by the spouse who say that they've been contributed, whether it is considered substantial improvement. So it's very hard to have an exact figure or gauge. What we normally advise clients is through the information instructions that we get, we give a rough gauge from what we think we have seen in past cases to give an estimate. We can only give a rough estimate of whether such acts would consider substantial improvement to qualify the asset to be put in the matrimonial pool.
Maybe I just add on. So basically, the court has set out certain guidelines. Substantial improvement, there must be an economic improvement to the asset. But when it comes to assessing what is substantial, what is not substantial, ultimately it depends on the facts of the case. It also depends on the views of the judge. So when both parties come before the judge and they present the evidence before the judge would have to assess all the relevant factors and make a decision, come to a decision whether there is a substantial improvement to the asset. So both parties, they would have to put in their evidence with an angle to persuading the judge that ultimately the contribution by that spouse, the other spouse, has made an economic improvement to the asset or otherwise. It's a matter of degree. So one example that I was sharing in the earlier slides was there's a comment by the court that being a nominal director may not suffice to be a substantial improvement to the business. So if one of the spouse is placed as a director, but basically his or her role is just to sign off papers, doesn't contribute substantively to the company's business, then maybe the court will take a view that it has not crossed the threshold of substantial improvement. But if this director is involved in the day-to-day of the business, maybe she runs the admin side of things, the HR, she contributes to the long-term strategies of the companies, and this is for a long sustained period of time, the court may tend towards the view that this other spouse have contributed substantially to the improvement of the asset, and all this have to be backed up by the economic indicators.
Sorry, I think I did not unmute myself. Okay, the question is this, guys. How is the treatment of overseas property in the division of matrimonial assets? Would similar principles still apply, or would the law of the land where that property is situated apply?
I'll answer this one. If the parties are having their proceedings in Singapore, then the Singapore law will apply on the division on how assets in Singapore as well as overseas will be divided. The problem is that with the Singapore decision on how a foreign asset is going to be divided, the question is, how will this Singapore decision be enforced in that country? So clients will be advised to also seek legal advice from lawyers practicing in those jurisdictions to find out whether a Singapore court order on division of matrimonial asset will be recognized in that jurisdiction. Okay, so the law follows here, but whether that decision of court in Singapore can be enforced in that country, we really need to seek advice of the foreign lawyers.
Mm.
Yeah.
So I suppose the takeaway where it involves overseas properties is that we will need to work with our foreign counterparts.
Yeah, that's correct. Yeah. So in such situations, if clients come to us, we will tap on our network of international lawyers, and we will get the help of our counterparts in the overseas offices. Yeah.
Okay, just digress a bit. Wee Swee Teow is also a member firm of a network called Macro International. This network has about more than 100 offices in, I think, more than 60 jurisdictions. So yeah, these cross-border issues and all, it was something that we'll be comfortable to deal with. There's another follow-up question to question number 1. The question is this: what are some provisions to protect a matrimonial home from being willed away to an outsider or charity, factoring in that the surviving spouse has been the sole breadwinner for the family for the past 20+ years? I suppose the context of this question is if the surviving spouse, okay, if the spouse that passed on had willed it away to somebody else, and all this while the surviving spouse has been paying for that property, then what can this surviving spouse do?
I think what the surviving spouse can try to do, if it has been paying towards the payments for that property, it could the spouse could try to argue it has equitable interest in that property. But the fact that you've been supporting the family in other ways by paying for household expenses and all that throughout the years, paying for the children's education, I'm afraid that it doesn't really help you if the owner spouse willed away the home away to a third party, without providing for the family. So if there are other assets, again, dependents can, as I said, can tap on the statute which allows you to apply for support from the deceased estate. But if that's going to be his one and only asset in the estate, then unfortunately, I think the family will be left exposed.
yeah, it is a very sad situation if that does happen. And I suppose if there is, we hope that will never come to that for other husbands or wives in this situation, because this is not a matrimonial issue, it's an estate issue, isn't it?
Yes, it is.
Yeah.
Right? Because matrimonial law doesn't come into play at all.
Yeah.
It is really the will and probate law coming in.
Yeah.
Maybe, Mr. Lee, I just add in a
Yes.
view. It also depends on how the matrimonial home is held. So basically, properties can be held in two manners. One is joint tenancy. Husband and wife are joint tenants of the matrimonial home. One is tenancy in common. So tenancy in common, each owner would have a distinct share. So for example, 50-50, 40-60, 70-30. So if we are talking about a joint tenancy, when once one of the owners passed away, right, the surviving owner will get the whole of the property. Because for joint tenancy, there is this concept of right of survivorship, where it will accrue to the survivor. So the other way is tenancy in common, where there's a distinct share. Then if the spouse, say with 30% passes away, the 30% will be dealt with in that spouse's own will. So for matrimonial home, you know, if parties want some security, they can consider holding it as joint tenants, so that if one of the other spouse passes away, then he or she would get the whole property. Yeah.
Okay. Yeah. Thanks. Okay, two more questions. I think it's close to 1:30. We will take two more questions. Let me look at this one. Similarly, okay, question is whether Singapore will work concerning distribution of assets overseas. Any one of you want to take this?
Yeah, I'll just quickly take this on. Basically, yes, that's correct. It does mean that you have to look at the law of that jurisdiction dealing with estate matters. Whether a Singapore will be effective in those countries. We always advise clients, if you've got assets overseas, please check with the lawyers in those jurisdictions whether our Singapore will apply there.
Yeah. And I suppose on a related note, if any one of us have assets outside Singapore, cross jurisdiction, multi-jurisdiction, do a proper planning, because besides matrimonial matters, estate matters, in some of these countries, there is inheritance tax, and that can really cause a lot of hardship if it's not properly planned. Right? I've come across situations where clients hold immovable property in USA in their personal name, and when they pass on, there's a hefty estate and inheritance tax over there. If he had simply, or he or she had simply interposed it with a company outside that's located outside the USA, that problem might not arise. So if you do have overseas assets, please talk to your advisors on this. It can be very painful if it's not properly planned for your next generation. Okay, last question. If a spouse comes under tax investigation after a divorce, where the assets have already been distributed, does the beneficiary spouse, would the beneficiary spouse be subject to clawback from the tax authorities? Any one of you want to take a stab at this?
I would think that it depends on the scope of powers of the tax authorities. I think that the tax authorities, they must act upon the basis, and usually it will be a statutory basis. So we will need to look at the statutory laws and see what powers does IRAS have, and to what extent is that power. But I mean, just taking a step, if the assets has already been distributed through the court process after a divorce, then on the face of it, it doesn't belong to the say, you know, to the original spouse anymore. So I think it will be quite difficult. I mean, subject to the statutes, for IRAS to say that, you know, I'm going to claw back from the other spouse.
Well, I think if I'm the other spouse, when IRAS comes after me, I will have to talk to either my tax advisor's friends or ourselves to say, hey, can IRAS do something against the asset? Which means that the spouse whose assets have been distributed to his ex-spouse will have to face IRAS alone. Right? Okay. Our friend who asked that question, feel free to contact any one of us. And maybe I will just end the webinar here. And thank you very much for all your questions and for participating. If you have any questions or any on any of the topics we talked about today, feel free to contact Chang Yang, myself, or Choon Wai. I cannot flash the our contacts here at the moment, but our names are all, our contact numbers are all on the website. So thank you very much. Have a wonderful afternoon and a week ahead. And may all our clients and marriages be strong and all these issues are just theoretical issues. Thank you very much. Good afternoon. Bye.
Thank you.
Thank you. Bye-bye.